Second case that we are going to hear arguments by video on is case number 22 CA 0016-M. Both parties are represented by counsel. Each of you will have 15 minutes to present your argument. The appellant, Attorney Clark, you may reserve up to 5 minutes for rebuttal. I'll be keeping track of the time since I'll be presiding here today. And you can see the panel includes myself, Judge Callahan, and Judge Hensel. Please don't refer to children by name. We ask that use initials or otherwise refer to them. I can assure you that Judge Callahan, Judge Hensel, and I have read the briefs, so we are prepared to proceed. Before I start the clock, do you know how much time you would like to reserve, Attorney Clark?
I'd like to reserve 5 minutes for rebuttal.
All right, and I'll let you know as you get close. With that, you may proceed. Thank you.
Thank you. If it may please the court and opposing counsel, my name is Attorney Rebecca Clark, and I'm here today on behalf of the appellant, Joseph Morales Van Brocklin. This matter comes before the court as a result of the trial court's failure to abide by the requirements of the UCCJEA as codified in the Ohio Revised Code, thereby creating an unjust result. Specifically in this matter, the appellant sought emergency custody and emergency jurisdiction under the UCCJEA of the Medina County Court of Common Pleas Domestic Relations Division. His child, who resides primarily in Louisiana, was with him for a Christmas break parenting time when he noticed a bruise of significant nature, and for which he took the child to a doctor. While with that doctor, the child revealed elements of sexual assault, thereby leading father to take the child then to the Alpha Clinic at the Metro Health Hospital System. Thereby, the child was evaluated forensically as well as physically by a treating physician who indicated that there was evidence of sexual assault. When father came to the appellant came to the Medina County Court of Common Pleas Domestic Relations Division, he brought with him all of this evidence. At the time, he had an ex parte hearing with a magistrate who indicated to him that he would in fact grant the emergency jurisdiction, but that he didn't want to see the doctor's records or any of the evidence that the appellant had brought forward. Rather, the magistrate indicated on the record that there would be an opportunity for a full hearing where all of that evidence could be presented. Shortly after that, the appellant received notice in the mail of a judgment entry that had been signed off on by the judge, stating that the emergency order had been vacated without hearing, and the child was to be immediately returned to Louisiana. This does not comport with the requirements of the UCCJEA as codified in the Ohio Revised Code. Specifically, the court was obligated to have a conversation or a judicial conference with the judge who presides in Louisiana. However, the revised code tells us that the appellant had the right to have notice of when that conference would take place, and the court may allow the appellant to participate in that conference, but in the alternative, if he were not permitted to participate in that conference, he would be given the opportunity for a full hearing to present any and all evidence prior to a decision about jurisdiction being made. In this particular case, that hearing never took place. There is no evidence of a judicial conference other than what is written in the judgment entry as issued by the trial court. The appellant was never notified of that judicial conference until he received the judgment entry. Thereby, the appellant was denied substantive due process in not being able to present any and all information that he had. While offered at the ex parte level, it was not taken into evidence, and there was no further hearing allowing him to present that evidence. The second part of this appeal has to do with the judgment being against the manifest weight of the evidence. Again, given very limited evidence because the court did not comply with UCCJEA requirements, the child at risk here had been the victim of sexual assault. And the decision to return the child without so much as a hearing or any other evidence being offered creates an unjust result. The child is placed right back into the dangerous situation from which she had escaped. The magistrate at the ex parte hearing had indicated to the appellant that he was troubled by the fact that no action had been taken in Louisiana, thereby placing on the record that he was fully aware of pending issues and litigation in Louisiana, but felt still that emergency jurisdiction was necessary in this case. Therefore, the decision to return the child without a hearing and without any further conversation is against the manifest weight of the evidence and creates a situation where the child is placed back in danger. Clearly, this event took place in January of this year. It is now October. As going through this process, it is realized by the appellant that some of the damage cannot be undone, that no matter what this court would issue or remand, that the child was placed back and that the child has since then been returned to that environment. However, it makes this appeal no less important. It makes this law no less important. The UCCJEA with emergency jurisdiction was created, codified, and as I revealed in my brief, there's a lengthy history of looking at it, revising it, and making it part of Ohio law. It was done because there's a purpose for it. And by the trial court taking the actions it did, it completely undermined that law, completely undermined the appellant's ability to seek safety for his child, and created this unjust end. So the appellant is asking this court to contemplate and take into account that substantive due process was absolutely denied here, and that the safety of a child was put in direct risk by the trial court's failure to comply with UCCJEA.
Counsel, what impact does this court's prior ruling regarding the child's home state have on this particular appeal?
So in this case, understanding that this appeal is being made, the motion was filed under emergency jurisdiction. So regardless of what state has final jurisdiction, and understanding that the emergency jurisdiction is literally just a temporary issue. It is an order designed to protect a child or to protect a person. So understanding that ultimately jurisdiction resides in Louisiana, an emergency order here, though, would have given my client, the appellant, the opportunity to protect his child until further protections could be put into place, either in Louisiana, or if this court were to hear the evidence and decide that the jurisdiction should remain here, that would be an issue under the UCCJEA.
Thank you.
Judge Callahan, any questions? All right. Thank you very much, Attorney Clark, for your argument. And you have a full 5 minutes, by the way, for your rebuttal. But at this point, we'll turn to Attorney Erb, and you have 15 minutes, sir.
Thank you, Your Honors. I believe in the original case, both Judge Teodosio and Judge Callahan were a part of that case in reversing the trial court's jurisdictional questions in regards to this minor child. First, I would state at this particular juncture, I believe this issue was moot. As a matter of course, the case has already been transferred and is a Louisiana case. Therefore, for this court to return or remand this case back to the trial court just doesn't make any sense, as Louisiana has already heard and decided on the very matters that Attorney Clark brings forth to the court today. Secondly, in the UCCJEA, there's no right to a full hearing. The court took jurisdiction under 3127-18A. There's no right to a hearing in C or D. In fact, C and D explicitly lay out the parameters by which this court can take emergency temporary jurisdiction. And in fact, if this court thinks that it's entirely true, everything that Joe says, if the court believes it's entirely true, this court cannot make a finding to return jurisdiction to Ohio permanently. That's not what the statute says. That's not what's intended. And in fact, if Ohio thinks it's more serious than Louisiana, it doesn't matter factually. It's in the Louisiana trial court's hands. Joe doesn't get to keep litigating it here because he's not getting the result that he wants in Louisiana. Okay, the Louisiana court actually heard everything that Mr. Morales said, and in fact, it's referenced in the court's January 12th order. the court references the Louisiana court's record in they issued a restraining order against the alleged perpetrator of these actions. That is attached and appended to the court's January 12th order. So again, there's no right to a hearing, and the court does speak through its orders. The statute is very clear as to what the parameters are. The court can grant it for a limited period of time. And in fact, in January 3rd, 2022, Magistrate Ross, in his ruling, indicated that they would maintain jurisdiction until one of two things happened. Either he talked to the Louisiana court, or B, a full hearing was held, and at that point, a different order would be issued. As such, and indicated in his January 12th ruling, which is again 3127-18A, which is the only section this court took jurisdiction over, indicates he issues the order. He spoke with the court in Louisiana. Oh, actually, this is Judge Kovac that then issued this order. But Judge Kovac issued the order that says, hey, look, we spoke to Indiana or Louisiana. This court no longer has jurisdiction. Louisiana already heard this. This is where Olivia lives now. Louisiana asked the court to vacate it. Louisiana has original jurisdiction. So at this particular
Counsel, was the court required to make a record of the communications it had with Louisiana?
Under my reading of 3127-18, there is no requirement of this to be recorded with Louisiana. But again, though, in the court's order, the court indicates, and we all know the court speaks through its orders, the court indicates that it did speak with Louisiana. It says exactly what the Louisiana court indicated to Judge Kovac at that particular time, and she signed off on it. But then again, Judge, I go back to, what's the remedy if we move this back to Medina? At this particular point, this issue would be moot. We're going to go on and put on the record that the court had a conversation with Louisiana, and Louisiana says, yeah, look, we've got this. And, you know, we're going to be right back to the same outcome that we have now, because Ohio can't take jurisdiction forever on this case. They have to return it whether or not Ohio believes Louisiana made the right decision. Louisiana has specifically said, hey, we've already made a decision on this. The emergency has abated. Ohio loses jurisdiction at that point. When the Louisiana court made a decision on this, Ohio loses jurisdiction. It says in 3127-18, that's exactly what it says is supposed to happen.
Well, counsel, does it make a difference under the statute that what happened in this case was the judge vacated the magistrate's order as opposed to we're transferring jurisdiction down to Louisiana? I mean, that the entire proceeding that happened has now been vacated.
Yeah, I can understand why Louisiana, and obviously I wasn't present for this conversation, but I can understand why Louisiana asked them to be vacated, because then you would have two competing orders. You had a Louisiana order that indicated that this alleged perpetrator was restrained from talking to or seeing this minor child, and you had a Ohio order that was directly in conflict with that essentially gave Joe, the appellant, full custody of the child until such a time as Louisiana heard it. So the vacated instead of the transfer, I believe, was so that there was not conflicting orders. And again, if you read the January 12th order, it's appended in there. They enjoined this particular person. I have it here right in front of me. Jordy Alamand, I believe is the gentleman's name. They restrained him from being able to see that child. And then they did go on and have a full hearing on the merits of that entire case. This case and Louisiana case have been moving in conjunction with each other. Unfortunately, that Louisiana case and what happened there is not part of the record. But just to reiterate, under this section, Ohio there's no requirement for a full hearing. Ohio can only maintain emergency temporary jurisdiction for a brief period of time. It's laid out right in there for a set period of time or for a time period until the other court does something. And I believe that it shows through the record here on that January 12th order from Judge Kovac that Louisiana court did in fact do something. So I submit it's both moot. His substantive due process manifest weight rights weren't affected. He had a full opportunity to be heard on this issue in Louisiana. This prevents, UCCJEA prevents forum shopping. And that's why we were here the first time, is Olivia was never a child of the state of Ohio for any purposes. That was reversed and remanded. So the only custody that this court could have over the minor child was under this very, very limited 3127.18 provision. Otherwise, these decisions have to be made by Louisiana to prevent constant relitigation of the same issues and different decisions in different states. So I would submit that it's moot. I would submit that his substantive due process rights were not affected. He had a full opportunity to be heard in Louisiana. Whether this court should or should not have granted a further extension of temporary jurisdiction is not what we're here about today. Louisiana clearly told Judge Kovac, we've got this. January 12th, her 2022 order. So I would ask the court to uphold, well, it's not even really uphold, but not remand this case back to the trial court. Thank you.
Thank you. Any further questions, Judge Hensel?
No.
All right, and Judge Callahan, no. Thank you very much, Attorney Erb. You'll have 5 minutes for rebuttal. Attorney Clark.
Thank you, Your Honor. I don't believe that the appellee is properly stating the law. Under Revised Code 3127.09A, it states that a court of this state may communicate with a court in another state concerning a proceeding arising under 3127.01 to 3127.53. So the 3127.18 that the appellee's counsel references is within that span. Specifically, however, Ohio Revised Code 3127.09B provides that the court may give the parties the opportunity to participate in the communication. If the parties are not able to participate in the communication, they shall be given the opportunity to present facts and legal arguments before a decision on jurisdiction is made. Clearly, the communication would have happened after the ex parte hearing, but before a full hearing would be held. Therefore, when appellee's counsel states that the appellant was not entitled to a full hearing, I believe that directly contradicts what the actual revised code says. The appellant was deprived of substantive due process. And regardless of how Louisiana handled this on their side, he was entitled to have a hearing here on emergency jurisdiction, which would have given this court more information in order to determine whether or not the efforts put into the Louisiana court satisfied the concern. So I don't believe that the appellee completely is stating what the law required to happen. There was no record made. To the best of counsel's knowledge, a request for that went nowhere. Understanding that our court subsequently went through a very trying time with the loss of a judge, this matter was swept under the rug and moved away from the trial court as quickly as it could be because the child then returned to Louisiana. Louisiana's statement to the court, whatever it was, there is no record of it other than what the judge placed into a written document. Therefore, I believe that the trial court did violate the Ohio Revised Code by failure to create a record of that communication, but then also, again, to give the appellant the opportunity to have a full hearing before the decision on jurisdiction was made. He was given that opportunity for emergency jurisdiction, but not again after the communication was held. And that is what the law requires. Therefore, understanding that the issue of that emergency order may be moot, the appellant submits to this court that the issue still remains in play. And that there was far more information to be provided had he been given that opportunity, which may or may not have affected the trial court's decision to vacate jurisdiction rather than transfer jurisdiction or to place additional restrictions in place as part of an emergency order.
Of course, vested interest isn't an issue in deciding jurisdiction under the Uniform Act, is it?
I don't believe so. I believe that emergency has to do with emergent issues. Yes. So I'm not drawing this court back to 3109 or anything of that nature.
Okay.
Just further information about the emergency issues.
Thank you.
I have nothing further at this
You have
time. Thank you.
Okay, let me double check with my colleagues. Judge Hensel, any other questions?
Oh, fine, thank you.
And what about you, Judge Callahan? All right, thank you, Attorney Clark, for your argument. On behalf of Judge Hensel and Judge Callahan, I want to thank you both for appearing here today, first of all, virtually, and for your excellent arguments. We'll take the matter under advisement, issue a decision in due course. Of course, the clerk of courts will mail you a copy of the decisions on the day it's released. You can also find our opinions on the Ohio Supreme Court's website.